This is a lecture from OpenTuition. To benefit from the lecture, you should download the free lecture notes from opentuition.com.
Right, we're looking at the United Nations Convention on Contracts for the International Sale of Goods, and in particular we're going to be looking at the seller's obligations. In the next lecture we'll be looking at obligations and rights and duties of both the buyer and the seller, but specifically we're looking at the seller's obligations. And we're looking to begin with at contracts that involve carriage. If the goods are not specific, then they are unascertained or unidentified. So specific goods are when you go to a seller and you say to the seller, I want that car. So you go to the dealer of previously owned cars and you look around and you decide, and you like the look of that one. I want that car, not a car, I want that car. And that is a specific good. If you were to go to a dealer and say, I want a Ford Focus, then that's an unascertained good, and they will come along and ask you the details, what colour, what size do you want? Do you want Ford, a 3-door or 5-door? Do you want a diesel? Or so they will ask all that detail, but at the time of your order and at the time of them accepting, or they will find the detail first, the goods that you are buying, this Ford Focus, that is unascertained. It's just a Ford Focus. When you go to the local shop, you don't normally say, I want 3 kilos of potatoes, and you're looking at a bag of potatoes. So I'll take that one and that one there. Similarly with fuel for your car, you don't go to a garage and lift up the cover of the tank and say, I'll have that litre there and 2 of those litres over there. So these are unascertained goods. These are goods which are being sold to you out of inventory, rather than specific goods that you can point to. I want that packet of biscuits. No, I want a packet of biscuits. So we need that difference between specified or specific goods and goods which are not specific, so unidentified or unascertained. So here we are looking at contracts involving carriage, and if the goods are not specific, therefore they are unascertained, they're unidentified goods from inventory, the seller must notify the buyer about the details of what is being sent. So the buyer, remember, we're talking international sale of goods. The buyer gives clear instructions as to what they want, the quantity, the description, the sizes, detailed measurements and so on. Gives clear indications about the goods allocated to the buyer's contract. The seller has to contact the buyer and say, well, I've taken these goods out of inventory and this is what I've taken out, and confirming, therefore, the order confirmation from the buyer. The seller says, this is what I have taken from inventory to satisfy your order. In addition, the choice of transport should be appropriate. If the goods are inanimate, if it's 4 tons of nails or screws or bolts, if it's 4 tons of an inanimate, even food, if it's an inanimate object, no, not food. If it's an inanimate object, books, then there's no problem with the mode of carriage, is there? There's no problem with the delivery in terms of these items will not deteriorate. But if it's livestock, cows, sheep, horses, hens, pigeons, whatever, if it's livestock, or if it's food, or if it's goods that require specific transportation, like refrigerated transport, even clothes. Clothes should be delivered on hangers, and hangers should be hanging on rails, and the rails should already be there within the carrier's transport vehicle. So inanimate or non-perishable goods, no problem. But if they're perishable, or if they're animate, or if they're particular, like clothes which shouldn't be piled into a bag and just sent off willy-nilly, they should be delivered on hangers. So perishable goods or things like livestock or clothing, then these should be placed in the hands of an appropriate carrier. Now, the timing of the delivery, well, we know from previous lectures that if you give goods to a carrier, the delivery is effected and the seller's responsibilities cease, unless otherwise agreed. They cease upon handing the goods over to that first carrier, or to the carrier if there's only one. Delivery should be effected on the date specified in the contract, or a specified period, and it may be a period following the completion of the goods, or following the completion of some extraneous event. And if no date or period is specified, the seller should deliver within a reasonable time. Now, you know what is a reasonable time. We came across this in the last lecture. A reasonable time is a time that is reasonable in the circumstances. Specific goods. Remember, these were if the goods are not specific. If they are specific goods, those particular units, those particular items, then this particular person, the specific goods are again delivered at the time they're given to the carrier. But it's this area here, this bit down here, is simply identifying what I have already said. That packet of biscuits rather than a packet of biscuits. Unidentified goods, goods sold from inventory, are not individually identifiable. So now we move on to contracts that involve carriage. Contracts not involving carriage is what we've just looked at. Contracts involving carriage. Now we're looking specifically at contracts involving carriage still. And the contracts involving carriage here, there are two important elements here. The two important elements are the delivery and the quality of the goods. Clearly, there are other important elements like the description of the goods and the quantity of the goods, but we're looking specifically here about delivery and about quality. And delivery, the seller is obliged to deliver goods and hand over relevant documentation relating to those goods and transfer the title to those goods as is required by the contract. If the place for delivery is specified within the contract, then delivery is effected at that specified place. But if no place is specified, then implied terms will apply. If carriage of the goods is involved in the contract, the seller's obligation will cease when the goods are delivered to the carrier. We've gone through that already. If unidentified goods are in the seller's inventory, then the seller's obligations cease at the time those goods have been now identified, wrapped in an appropriate manner, and the buyer has notice of that fact. If they need something else done to them, they need weighing, for instance, then delivery is effected when they're taken out of inventory, they're weighed, they're valued, they're priced, they're wrapped up in a form suitable for delivery, and the buyer has notice of that fact. That is what is meant by upon placing the goods at the buyer's disposal. If specific goods are involved, again, seller's obligation ceases when the goods are placed at the buyer's disposal. And if none of these three place situations is apparent, then the seller's obligations cease when they're placed at the disposal of the buyer, at the seller's place of business. So we're still talking about international sale of goods. We're still talking about somebody in Romania compared with somebody in the Czech Republic. But once those goods have been placed at the buyer's disposal and they're still at the buyer's place of business, they've been delivered, then on that occasion, then they are delivered. Moving on. That was delivery. Now we're looking at quality. A seller must deliver goods which are of the quality, quantity, and description. I mentioned quantity and description were two other important elements. Quality as well. And we're looking here at a word which is a single word which covers quality, quantity, and description, and that is conformity. The word conformity, and that the goods delivered must conform, or they are conforming with, the details of the contract. And they're contained or they're packaged in the manner required by the contract. But if the contract fails to specify quantity, quality, and there's no description within the contract, then the seller's responsibilities are dramatically reduced in terms of specifics. The seller must nevertheless meet conformity requirements, but these are massively reduced if there is no specific detail about quality, quantity, and description. Then the goods delivered should be fit for any purpose which has been specified, but if no purpose is specified, then the goods delivered shall be fit for our purpose. They should be fit for the purpose where those goods of that description would normally be used. But let's just take, and I'm going to move down the screen to get a little bit of space. Let's just take the product called Hessian. Hessian is a material, it's a man-made material. And Hessian has got a number of different uses. Top quality Hessian can be made into ladies' dresses. And no self-respecting lady would have a wardrobe that doesn't have a Hessian dress within that. This is top quality stuff. Going right the way down, wall covering. Lower quality Hessian, wall covering, or mail bags sewn by prisoners in prison. They'll sew Hessian into mail bags to be used by the postal system. So Hessian has got a number of different uses, and where goods have different multiple uses, the seller has the responsibility, if the description is not specific enough, the seller has the responsibility of delivering Hessian which is of merchantable quality. It is suitable for our purpose. And if it's equal quantities sold for dresses, for wall covering and for mail bags, then the seller, he can't know. How can he know that this 40,000 meters of Hessian is to be used for ladies' dresses? He can deliver Hessian which is appropriate for making mail bags, and no one can complain. So the seller has the responsibility to deliver goods for the purpose for which goods of that description would normally be used, but we have a problem. And buyer beware. There's a Latin expression, caveat emptor, let the buyer beware. If you order Hessian and the seller delivers Hessian to you, which is suitable for mail bags, you can't complain because you wanted it for ladies' dresses. If a sample is offered, this is important, stupid though it may be. If a sample is offered for inspection, the seller says, would you like to see a sample? And the buyer says, no, I'll not bother, I'm trusting you. And if the goods delivered are the same as the sample that was offered, and the sample that was offered, you could see if you had looked, you could see that it would deteriorate, and the goods that are actually delivered deteriorate in the same way that you could have seen the sample would deteriorate, then it's your loss. You should have looked at the sample. So if a sample is offered for inspection and the goods delivered are exactly in accordance with the sample that was offered, then that's the seller's responsibilities discharged. And if they do deteriorate, then that loss is yours. And it's irrelevant whether you did or you didn't inspect the sample. So sale of goods by sample, you can describe that sale as a sale of goods by sample. And if no sample is offered, then by default, it's a sale of goods by description. Now, in a sale of goods by description, the goods actually delivered must be exactly the same as the description that was given. Exactly the same. No tiny variation is allowed. And if the sale of goods is a sample which is offered and the goods are described, then the goods delivered must be exactly the same as the sample that was offered and exactly in accordance with the description. That should be packaged. Goods should be packaged in a manner which is normal for goods. If you order a ton of toothpaste from me and I deliver this ton of toothpaste in just one big vat or substantially large paper bag or Hessian bag, that's not really what you would have expected, is it? You would have expected it to be contained within tubes of toothpaste, and those tubes would have been carefully packaged so that they don't squash or leak and toothpaste is all over the carrier's transport. So goods delivered should be packaged in a manner that is normal for goods of that description. There's no obligation on the seller to make sure that goods comply with legislation in the buyer's state. So if you in Nepal are buying goods from someone in Germany, it's not incumbent upon the German seller to make sure that those goods are not illegal, that they don't disagree with Nepalese legislation. Unless the same legislation applies in the seller's state, in which case the German should think very carefully about, if I were to deliver these goods, would they comply with legislation in Germany? Unless the buyer made the seller aware, so the Nepalese buyer contacted the German and said, this is the relevant legislation in Nepal. I trust that you can deliver goods which comply with that relevant Nepalese legislation. Or the seller knew the requirements. If the seller knows and has previously dealt with buyers from Kathmandu, then clearly the seller is aware of the local legislation in Nepal and therefore should deliver goods which do comply with that legislation. The seller won't be liable for breach of conformity requirements. Remember, conformity, quality, quantity, description. In the situation where the buyer knew, the buyer knows that they're not going to conform. It's not the seller's fault. The buyer knows what the local legislation is, and then it's not incumbent upon the seller to check. But he will be liable if the non-conformity existed at the date the title or the risk to the goods passed to the buyer and the buyer didn't know. I'm going to put that in. And the buyer didn't know or could not reasonably have known. So in that situation, the seller will be liable if it existed when the risk passed to the buyer and the buyer didn't know. This is so even if the failure to conform became apparent only after the date that the risk passed. In addition, the seller is liable even though the sale was 2 years ago, if there is a guarantee period, because the seller is saying, and I shall guarantee my goods for. I think Kia cars, am I not right that Kia cars guarantee their engines for a period of 7 years? So a buyer of Kia cars in the UK from, is it South Korea where Kia cars are made? A buyer from the UK of cars, Kia cars from South Korea, those cars have got a 7-year guarantee, I think. And so the seller in South Korea will remain liable even though the risk has passed, even though the ownership has passed. Finally, if the quantity delivered is less than the quantity ordered, but it's before the contract date, the seller has got the opportunity to make good the shortfall. They've ordered 4,000, he delivers 3,000, but he delivers before the contract date, before the due date for delivery. So we still have this week, say, where the seller can deliver the remaining 1,000 and without penalty. There is an exception to that, and the exception is where the buyer incurs additional costs. For instance, the buyer cannot move those goods on unless there are 4,000 of them. So the buyer is now faced with the prospect of having to store 3,000 goods until the supplementary delivery arrives. And in that situation, the only exception, therefore, as a result of the reduced quantity the buyer incurs, and in that situation, the buyer can seek compensation in the form of damages. The buyer's responsibility, I'm down here with all this Hessian, so I'm going to get rid of that. Get away. The buyer's duty to examine the goods. I find this a tricky area. I do find this a tricky area. As soon as possible after delivery, the buyer should examine the goods. Okay, that's normal, surely. And when the buyer is going to deliver onwards these goods, so the buyer receives them from Germany into Nepal, and the Nepalese buyer is then going to ship them straight on to China, then in that situation, it's not reasonable to expect the buyer to unpack all these goods to inspect them before he then has to pack them all up again and send them off to China. So in that situation, it's acceptable that the earliest inspection should be on delivery to the Chinese subsequent buyer. Notice of non-conformity should be given to the seller within a reasonable time. I'm not going to bore you again with reasonable time, but notice must be delivered within a reasonable time of when the non-conformity should or could have been discovered. Failure to give notice within that time will lose the buyer the right to claim compensation to sue. And if non-conformity is not given within 2 years, then the buyer loses the right to compensation. The difficulty I have is this. Goods like washing machines, refrigerators, white goods these are called, dishwashers. Goods like this tend to be wrapped very carefully. They tend to have polystyrene packaging, then wrapped up in cardboard carton, and then loaded onto a wagon carrying maybe 20 or 30 or 50 of these white goods, these substantial kitchen equipment goods. Now, if you're a buyer and you order 50 washing machines, are you going to unpack those washing machines, or are you just going to put them into your inventory, into your warehouse, and wait for 50 different people to come and order those washing machines? And I suggest to you that that's actually most likely to happen. So you don't unpack them and you don't inspect them. Hopefully you'll get rid of them within 2 years. So hopefully it will be the case that as you deliver them, they will be unpacked by the subsequent purchaser, the end user, and the end user is then going to contact you and say, oh, that washing machine you delivered me has been damaged in the side. But that may not be within the 2 years. So this concept about as soon as possible after delivery, the buyer should examine the goods, is that right? Is that reasonable? And that's the problem I have when I'm considering this particular point. Failure to give notice, non-conformity is not given with 2 years, you lose the right. But if the seller knew of the non-conformity and failed to disclose it, then the seller will remain responsible. Pass the ladies' dresses and the mailbags. Third-party rights. Seller must deliver goods which are free from any lien or encumbrance or any other legal rights over the goods. What the seller is saying actually is that the seller has the right to sell those goods. Those goods belong to him, or he has been given the right to sell them. He must deliver goods which are free from any third-party right or claim, unless the buyer knows of that third-party right or claim and still wants to go ahead and buy those goods. Special provisions relate to whether right or claim is based on intellectual or industrial property. So there are special provisions about that, but I don't think we need to worry about those special provisions, other than what's coming now. These situations, the seller delivers goods that are free from these property rights, provided the rights exist in the law of the state where the goods will be resold, or the state where the buyer has a place of business. We don't know whether the buyer is going to resell the goods, if he's, as in resell them internationally. We have no control over that. But we do have control over the legislation within the state of the buyer. Intellectual property includes trademarks, patents, and copyrights. Such a contract where these third-party property rights are infected must involve the buyer's awareness. It's amazing how many students know of the existence of the copyright that BPP and Kaplan and OpenTuition have with reference to their material. And yet those same students are asking on the general forum whether anybody, for instance, has a soft copy of the BPP F4 Global Study Text that they'd be prepared to share. That is a breach of copyright. That is a criminal act. And not only is it criminal for the person to ask, but it would be equally criminal for the person who is asked then to say, yes, I have, and for them to send it. Not only is it a criminal act for them to send, but it's also a criminal act for this person to possess a soft copy of the BPP or Kaplan or Becker or OpenTuition material without consent. That's food for thought, isn't it?